everyone. I welcome you all to today's HIT series session, that is High Impact Topic Series session, abbreviated as HIT. And in this session today, we are going to talk about a new development that has happened. The Government of India has withdrawn the Personal Data Protection Bill. Yes, so we are going to have our discussion around this particular topic in the following sequence. We shall see why it is a news. We shall be understanding about the development. Then, what was the Personal Data Bill all about? Why has the bill been withdrawn now by the government? The reasons behind this development. Then, the recommendations by a joint parliamentary committee. Yes, so this bill has been withdrawn because a joint parliamentary committee has given certain recommendations against this particular bill, so the government has to rework through it. So I have already revealed a lot, but we shall be looking at way forward, because data protection we know is a problem, and whenever we are discussing a problem, it has to be a rule for your UPSC CSE preparation that whenever you are considering or understanding a problem, you must always be led towards, or you must always be able to find out certain way forwards, right? And thereafter, towards the end, we shall look at the prelims and mains based practice questions for you all. So now, without further ado, let me take you towards the topic. The very first in the sequence is why it is in news. So the Government of India has withdrawn the Personal Data Protection Bill from the Parliament as it considers a comprehensive legal framework to regulate the online space to boost innovation in the country through a new bill. So it is going to bring about a fresh bill, because certain developments have already been happened. When the bill was framed, this particular bill, when it was framed, it was way before, right? Personal Data Protection Bill has been in news for a long time now. And now, with the advent of time, certain new changes have to be introduced, and hence a fresh bill shall be introduced maybe in the upcoming session of Parliament, since the monsoon session has already been adjourned sine die. So monsoon session for 2022 is over. Next up would be the winter session. Maybe we can see a new bill regarding personal data protection by then. So let's understand about the Personal Data Protection Bill. What was in there, right? What were the, because see, since a bill was already there, it will obviously work as a blueprint or a guiding document for the upcoming bill whenever it will be coming up. So let's understand this particular bill, what it was all about. So the bill seeks to provide the protection of personal data of individuals. The bill governs the processing of personal data. By whom? By the government, by the companies incorporated in India and foreign companies dealing with personal data of individuals in India. So everyone who may be interacting with the personal data of the people shall be liable towards the governance of personal data. The obligations of data fiduciary. Personal data can be processed only for a specific, clear and lawful purpose. No illegal work should be done using your data. For example, frauds, banking frauds, internet frauds, how they are done? They are done because they get access, the fraudulence, they get access to your personal data. How do they know your account number? How do they know your credit card or debit card number in the first place to have a false call with you and ask you for OTP? That is because they must have got the data from somewhere, right? So additionally, all data fiduciaries must undertake certain transparency and accountability measures. Those measures are implementing security safeguards such as data encryption and preventing misuse of data, and instituting grievance redressal mechanism to address complaints of individuals. They must also institute mechanisms for age verification and parental consent when processing sensitive personal data of children. Have you heard this word encryption before? Yes, if you are a WhatsApp user, which most of you are, so you would have heard the word encryption. This is coding of data in such a manner that the person who has sent a particular data and the person to whom that particular data has been sent. Only these two people can access the particular information and nobody else in between. This is how it works. So I have just superficially explained to you how encryption works. And as far as the grievance redressal mechanism is concerned, that is to be there with every country, even company, even with the government, it has to be there, right? So that's why you have customer support, all of these provisions. With whatever app you are using, you can always access to the customer support of that particular application. Then rights of the individual. They can seek correction of inaccurate, incomplete or out of date personal data. They can have personal data transferred to any other data fiduciary in certain circumstances. They can restrict continuing disclosure of their personal data by a fiduciary if it is no longer necessary or consent is withdrawn. Now, who is the fiduciary here? If you are interacting with WhatsApp will be the fiduciary. If you are interacting on Instagram, if you are using Instagram, your preferences, what are your searches, which all pages you are following, all of that is what? That is your data. That's your personal data. So Instagram will be the fiduciary here. So this is the meaning of fiduciary over here. Now, grounds for processing personal data. The bill allows the processing of data by fiduciaries only if the consent is provided by the individual. However, in certain circumstances, personal data can be processed without consent also. So what are those circumstances in which the consent is not provided but still your data could be used? If it is required by the state, that is the government, the country, for providing benefits to the individual. Then if it is required in legal proceedings, and apart from that, to respond to a medical emergency. In these three circumstances, your personal data, even without your consent, can be accessed and used by the fiduciary, maybe to provide it to the state or to give it for the legal proceedings or respond to a medical emergency, right? Now, if you have, had this pop-up on your Paytm that can we save your card as per RBI guidelines, and you have ticked it and submitted it, you have said yes to it, only then they will save your card. This is called taking consent. I hope you have understood that. I had to give that example earlier. I just missed out on it, so I'm giving it to you right now. We are still on this slide. Late, but not too much. And anyways, so the key terms in data protection, what are the key terms you would come across? So I'll let you go through them now itself, so that if some of it comes in the UPSC exam, be it prelims or mains, if you have watched this video, you are a step ahead of your competitor. So they are data principal, data processor, data fiduciary. I've already made you understand about the fiduciary. Then the personal data, what it is all about. Non-personal data, what is that? Data protection authority. So let's go through them one by one. Data principal, the person to whom the data is data in consideration belong, that is data principal. So if it's your data, you are the data principal. Data processor, a person, state, company or any entity which processes the data on behalf of someone else. So WhatsApp, if it is giving you your data to, let's say, the police for any particular reason, then WhatsApp is the data processor handling the data and giving it over to the police. Then data fiduciary, a person, state, company or any other judicial entity which control the various aspects related to data storage and defines how can it be processed. Again, that would be the interface you would be using. Personal data, it is any set of data that may contain information that can reveal personal traits of a human being and can be used to single out the person. For example, your birth date. For example, your password. For example, your account number, your mobile number. Through this, a person, any entity could reach out specifically to you. somehow you can be filtered out of the lot using such information. So non-personal data, what is that? Data sets which do not contain any personal information and instead have information on detailing the larger trends such as the income group of a town, the average age, the male to female population ratio, etc. Then the Data Protection Authority, a regulatory body for the act which can have adjudicating powers and pass executive instructions in case of conflict between two parties under the data protection. So Data Protection Authority would be the one that would be first of all assigned by the regulatory body, by the state, right, which has particular powers to act as data protection authority and which can resolve the conflict or investigate into the conflict between the two parties, which could be you and WhatsApp. So the authority that you will go to with such a complaint is your Data Protection Authority. Now, why has the bill been withdrawn? Let's understand that. Actually, the JCP, Joint Committee of Parliament, JPC, Joint Parliamentary Committee, it has recommended a lot of amendments. So government found it more feasible to instead come up with a fresh bill itself. So the Joint Parliament Committee analyzed the Personal Data Protection Bill 2019 in detail. So yes, the bill was not yet passed by the Parliament. It was there since 2019. See, I told you that it has been in news for a long time and we have somewhere definitely covered this. Even you would have if you are preparing for some time now, but if you are a fresher, you may not have heard about it. But now that it is crucial for you to understand about it, since it is in news for this particular reason, please pay attention. 81 amendments were proposed and 12 recommendations were made towards a comprehensive legal framework on the digital ecosystem. 81 amendments to a bill and 12 additions, recommendations for the bill. Considering the report of the Joint Committee of Parliament, JCP, a comprehensive legal framework is being worked upon. Hence, it is proposed to withdraw so that a better bill could be brought about instead of that. Now, let's find out what is compliance intensive. The bill was also seen as being too compliance intensive, as in if the company is not complying, if WhatsApp refuses to comply with Indian rules and regulations, what will the government do thereafter? What will happen to data thereafter? So it was too much dependent on the fiduciary entities, the data processor entity. So the revamped bill will be much easier to comply with, and especially for startups. Then pushback from stakeholders. The bill had faced major pushback from a range of stakeholders, including the big tech companies such as Facebook and Google, and privacy and civil society activists as well. So these big stakeholders, they were not finding the bill feasible for compliance, and in fact it was very conflicting with their policies, and we cannot escape their usage, right? We can't push ourselves back from the entire world. So that's why we need to find ways for ourselves to actually make it work, to bring everything on the same page, on the same line. And on that note, there were also issues with data localization. The tech companies questioned a proposed provision in the bill of data localization. Let me tell you what it was about. Actually, the government was seeking a change in the data policy and asked these companies that Indian data should be stored in Indian data banks only. It should not be stored in any other country whatsoever. So this was a law that was not going well, or this was a clause in the bill that was not going well with the stakeholders. So under the data localization, it would have been mandatory for the companies to store a copy of certain sensitive personal data within India, and export of undefined critical personal data from the country would be prohibited. The activists had criticized that it would allow central government and its agencies blanket exemptions from adhering to any or all provisions of the bill. So basically the activists were like, if we go on with this particular step, we never know what data of ours the government will try to access in the name of keeping it with itself, and not even we would not be able to ask the company what all sorts of our data is being checked by the government. The reason for it being that it would categorize any of the data as critically personal data. So now the government has access to it, but we have no qualifications for a data to be critically personal, to be called critically personal. So that was a problem. Now there were also delays in implementation, as we have noticed that it was there since 2019 and till now it's 2022 right now. Even half of the year is already gone. And on that note, if your preparation is not going at par even right now, it's time to pace up, it's time to buck up. So delay in the implementation was there, and obviously the time has changed. 2.5 years have passed since 2019, so modern changes accordingly were required. So the delays in the bill had been criticized by several stakeholders, pointing out that it was a matter of grave concern that India did not have a basic framework to protect people's privacy. Now, what all recommendations have been made by Parliamentary Committee? We'll go through the major ones, that is the 12 recommendations, and we won't go through the entire amendments, which are 81 in number. So the Joint Committee of Parliament proposed 81 amendments to the bill and finalized by the Shri Krishna panel, and 12 recommendations including: number 1, broader data protection, expanding its mandate to include discussion on non-personal data, thereby changing the mandate of the bill from personal data protection to broader data protection. So the bill was what? The bill was Personal Data Protection Bill. Now the Joint Parliamentary Committee has recommended that why just personal data? Every kind of Indian data that is being generated in India, being collected in India, should be governed by the government, because somehow, somewhere it could always be used for or against India. So regulation of social media was another recommendation. Changes on issues such as regulation of social media companies, they have to be there in the data protection bill. Then trusted hardware, using only trusted hardware in smartphones among other things. Data protection in line with Supreme Court judgment. The new bill will incorporate the broader ideas of data protection as recommended by Joint Committee of Parliament, and it will be in line with the Supreme Court's landmark judgment of 2017, in which it held privacy as fundamental right. You need to tell me that privacy is your fundamental right. This has been recognized by the Supreme Court under which article or articles? Put your answer in the comment box. The Data Protection Bill will do away with some recommendations by the JCP, such as including trusted hardware and local storage of some kinds of personal data within the boundaries of India. Instead, it will add these ideas in larger framework for the internet ecosystem, which will replace the New Information Technology Act 2000. So this one, new data protection bill, may not have, and it will find another way around to do the same thing. Do away with the classification of personal data from the perspective of data localization. The new bill could also do away with the classification, that what is personal data, right? So from the perspective of data localization, that was very much questioned by the stakeholders. The only use of classification for awarding damages to the people whose personal data may have been compromised by an entity. So they'll say that, see, this person's personal data you have compromised. Now you are not allowed to use its his or her personal data anywhere else. In fact, you are not allowed to store it anywhere else. You have to keep it within the bounds of the country itself. Now, what could be the way forward as far as the personal data protection or data protection in general as recommended by the Joint Parliamentary Committee goes? So data localization, is our first way forward. Of course, it is required no matter how much issues the stakeholders may have with it. See, data today is like gold. Data is the new gold, right? So the data is sold in the market like a commodity, and it is because of this selling of data that is being done by the stakeholders, the companies, because of which they have a problem storing the data within India. But something so personal that could be used against you at any point in time, that could be used to harm you at any point in time, it needs to be localized, right? No matter how much of problem and how much cut off of profit happens to the companies, they have to respect their consumers first. So the data should be stored in a region that is trusted by the Indian government, and that data should be accessible in the event of a crime. The government may also consider allowing cross-border data flow only to the trusted geographies. That means if the government does not want in any case its data or its people's data to go to China, it should have the power to do so. Then comes in the classification of data. A new bill could also do away with the classification of personal data from the perspective of data localization. Okay, I've already told you this particular point. It is already being thought about, and it is also put by me on in your way forward list. So you can also use it as your way forward even in your mains answers. Now let's look at the prelims practice question. We have covered the information regarding data protection bill as much as it was required to understand from UPSC CSE's perspective. For any doubts or for any other queries or even for the suggestions and improvements, please use the comment box liberally. Then the prelims based practice question. Right to privacy is protected under which article of the Constitution? So you already have this question being asked by me. Your options are over here, however, just to make your task a bit easier. Your options are A, Article 15, B, Article 19, C, Article 21, and D, Article 29. Well, your answer is C, Article 21. So I have asked you this question in the middle of the video. If you have put it already in the comment box below, it's great. If not, by the end of the video you were to get the answer. So the answer is C. Actually, this is a previous year question, so that's why it's very crucial. That's why I put it even before, and right now in prelims practice question also I'm putting it across just to let you know that this topic is very, very crucial from UPSC CSE's perspective, since UPSC is taking interest in the peripheral topics of this kind itself. It has already asked about it once, and since now it is this development has made it to come in news once again, there is a lot of possibility that it could be asked once again in paper in whatever manner UPSC feels like asking about it. So the mains based practice question for today is: examine the scope of fundamental rights in the light of the latest judgment of Supreme Court on right to privacy. This judgment we are talking about is of 2017. I have already mentioned earlier in previous slides also. Anyways, you need to answer this particular question in 150 words and send in your answers to us on WhatsApp to get it reviewed. This is it for today. I shall see you again tomorrow. Till then, take care, stay tuned. Thank you so much for joining in.